Thanks again for coming. I appreciate everyone who stayed on. It's really nice to see you all again. Once again, thanks to the Dev Office for hosting this. We know that we're also doing it on live Zoom kind of webinar. So also to everyone who's watching at home. In terms of what we're doing today, this is Dr. Charlotte Proudman, and we will be talking to her about women in law as part of the celebration of 50 years of women at King's, but also as part of the King's College Law Society event. This is Beth. Beth is the Women's and Non-Binaries Officer alongside Maya, who unfortunately can't be here today, soon to be the Gender Equalities Officer, we understand. So I'm going to stop talking now. I'm going to let you do all the talking and the interviewing. And we'll do a short Q&A about 15 minutes before we wrap up. Okay.
Hi everyone, and just before we start as well, we thought it'd be good to do just a quick content note because some of the discussion might cover issues around sexual harassment, child marriage, abortion and other issues. So there is links to the university counselling services, but if anyone does want to leave at any point, it's completely up to you and there'll be no questions asked. So just to start off, Charlotte, would you be able to give us just an overview of your career and the kind of work you do and what it really involves?
So thank you very much for inviting me to come today. It's really nice to be back at King's. I haven't been here for quite some time, although I just finished my fellowship at Queen's College, so I moved from one to the other. But so I'm a barrister at Goldsmith Chambers in London, and I specialise in violence against women and girls, predominantly in the areas of family law and human rights law. And I, as I say, finished my fellowship now at Queen's College, where I continue to teach and supervise at the Department of Sociology. And I've worked on a number of different campaigns, which I know we're going to come on to, dealing with gender equality and progressing that through the law.
Amazing. And I think it's hard to know where to start with all the different campaigns.
Yeah.
Like those one that you mentioned earlier was kind of around consent in different cases that you've been involved with, particularly around coercive control. And I suppose, would you be able to tell us a bit more about that, kind of what it involves and how it's like, how your work has impacted the law in that area, I guess?
Yeah, so I mean, I've worked for quite a long time and still do on a daily basis on rape cases, domestic abuse and coercive and controlling behaviour. Those are predominantly my areas of practice. And last year I was involved in a landmark guidance case, which is a Court of Appeal decision of HN and others. And this was the first time that the Court of Appeal looked at coercive and controlling behaviour in terms of it impacting in the family courts and recognising it as a form of domestic abuse. And it also addressed the fact that, of course, coercive controlling behaviour impacts predominantly upon the parent or a mother or a woman, but it also impacts upon children living in domestic abusive households. And the Domestic Abuse Act 2021 Section 3 made clear that children are also now considered to be and defined as domestic abuse victims. So that case is really powerful in terms of recognising coercive and controlling behaviour as a form of corrosive, insidious abuse within often a family context. I also represented Kate Griffiths, who's a Member of Parliament. Some of you might remember her ex-husband, Andrew Griffiths, who was a former Member of Parliament. And she came to me with really what can only describe as a horrendous story of what the abuse that she'd experienced at the hands of Andrew Griffiths, including rape while she was asleep, which went on for over 10 years of their relationship and marriage, domestic abuse, coercive control, and verbal abuse towards their 8-week-old baby. And I represented her. We got the findings, so I can talk about this. And then there was a long fought out battle in the higher courts as to whether she could speak publicly about the abuse that she suffered. And in the family courts, there is effectively anonymity across the board. So this was really quite a significant push, if you like, to allow her the right to speak. And one of the things it relied upon was her Article 10 and Article 8 right, in that she, as a victim of domestic abuse, had a right to be able to speak about the abuse that she had suffered. And to prevent her from doing so would, in effect, be another form of controlling coercive behaviour in preventing her from sharing her life story, especially as a Member of Parliament and working with and on behalf of other victims. So it was a really important case in terms of setting that precedent, and the language that's used, particularly in the High Court by Mrs. Justice Leben, was very powerful in referring back to the Me Too movement and making sure that powerful men, especially such as Andrew Griffiths at the time, when he was a minister, are held accountable because, of course, he was involved in voting, for instance, on the upskirting bill and other gender equality initiatives, whilst at the same time raping his wife behind closed doors. And it's important as a society that we're aware of what is happening behind closed doors. And as a feminist, I'm a strong believer in making the personal political. And so that was a huge case. Went to the High Court, the Court of Appeal, and then I'd been working for a really long time on an issue that I felt very strongly about. And I've worked with Jess Phillips on this issue and members of the House of Lords when the domestic abuse bill was progressing through the Houses of Parliament. And I wanted to insert a number of amendments, one of which was to make refuge addresses confidential. The government didn't support that. Another one was to make sure that victims of domestic abuse never have to pay for their perpetrator's costs of child contact in a supervised contact setting, which can cost around £150 a week. So it's quite a lot of money. And there were a number of other initiatives that we worked on, including judicial training. Now, whilst that was not successful in terms of getting the amendment, what it was successful in doing is raising public consciousness about these particular issues. And so with Kate Griffiths, she, as I say, having been found to be a rape victim, nevertheless, she was ordered by the courts to subsidise her rapist's costs of child contact, which had to take place in a supervised setting because, as you can imagine, the risks were very serious. And at the same time, she was not receiving any child maintenance. So I argued that was a breach of her Article 8 rights and indeed discrimination on ground of Article 14, gender discrimination, being a victim of domestic abuse. And we won the appeal in front of Mrs. Justice Arbuthnot, and that became, in effect, a guidance case where it sets out a strong presumption against a victim ever having to contribute financially towards her perpetrator. And in terms of the refuge amendment, which, whilst not successful in terms of in the House of Parliament, I've now brought a case along with Women's Aid, Refuge, Latin American Women's Aid, because of considerable concerns that refuge addresses, as I say, they're not confidential. They're often, unfortunately, publicly available in terms of within the court papers that are given to parties. So in those individuals that have access to that documentation, the addresses become known. And in one case, the father became aware of the address where the mother was living in a refuge. And despite, of course, serious allegations of domestic abuse, which she said were not taken seriously by the family court and were minimized, he then stalked her after contact had happened. And then he abducted the child and took the child to Ireland. The mother couldn't go to Ireland to collect the child because her passport had been confiscated by the High Court. So the manager from the refuge had to go to Ireland to collect the child and bring the child back. And there were concerns that this has then occurred in another case. So I use that as an opportunity to ask the High Court to give guidance. The President will hopefully deal with this issue next month.
And I think a question that comes up for me, just hearing all of that, is kind of how well do you think the law is protecting victims of domestic abuse at the moment? Like, how well do you think it really tackles that issue? Because I know you touched on a few of the problems there with the various amendments. And really, do you think the law is doing a good enough job at the moment?
I think the law is just one tool in trying to protect or prevent domestic abuse, amongst many others, which of course are not satisfactory. So for instance, making sure that women have access to refuges and women have access to state benefits and they don't fall through the cracks. That in terms of providing a support service and network is not available often, especially for migrant women who don't have recourse to public funds. The Istanbul Convention, of course, due to be ratified and will come into force on the 1st of November. And despite that, the government have an exception not to provide the same level of support and services to migrant women, the most vulnerable group in our society. So even just in terms of the public sector, it's not necessarily supporting victims. In terms of the law, I'm afraid, my view is I think there are systemic problems within the legal system. And I think that there is and continues to be ingrained sexism within the justice system, whether that's conscious in some cases or unconscious in others. And I think it's perhaps a deep-rooted issue, which has been going on obviously for centuries since the law was created. And I know we're going to speak about abortion, for example, as one example of that, where women's lived realities and their experiences are not reflected in the law. So the example, for instance, of a woman having to pay for a perpetrator's costs of contact, victim, the fact that that is not already addressed in the law and therefore serves to continue the abuse and the control, and the law should never be used in that way. So it's not even in terms of the law necessarily not protecting victims, it's actually sometimes being actively used as a tool to continue the oppression of women. So I think that, no, I don't think the law is unfortunately necessarily supporting the progression of women's rights and ensuring gender equality.
I suppose linking to that, and in particular to children's rights, which obviously come up in this area as well. I know you've been involved a bit with child marriage and campaigns around that. And I suppose, can you tell us anything more about that in the law?
Yeah, so of course, many of you will be aware that you could marry at the age of 16 with parental consent. And a key concern around that was that the UK government, was actively participating in encouraging other countries abroad to change their laws when it came to child marriage, to increase the age. And Bangladesh was one such example. So when they were doing this advocacy work, the government in Bangladesh said, but you can marry in England at the age of 16. Isn't that an example of child marriage? And you're here preaching to us about what we should and shouldn't do, but actually look at some of the issues at home. And so we've worked for about 5 years on trying to change the law to increase the age of marriage from 16 to 18, and also to criminalize child marriage, which includes customary marriages, religious marriages, conventional marriages, and so forth, not necessarily, of course, civil marriages. And it was a long-fought campaign of the coalition of women's rights organizations, which were absolutely phenomenal. And it really was like a sisterhood in working to progress this. And fortunately, this year, the government voted for it, and it is an act of parliament. So that was a tremendous success, but it only operates in England and Wales, because Scotland, you can still marry there at the age of 16 with parental consent. And some of the other campaigns that we worked on successfully this year, the same coalition of organisations, was to criminalise virginity testing and to criminalise hymenoplasty, which were actively being performed in many private medical clinics in London, other parts of the country. And in one of my own cases, I represented a woman who was a complainant of domestic abuse and coercive and controlling behaviour. She'd married her partner, her husband, and he had applied for an annulment on the basis that they had not consummated the marriage. She said they had consummated the marriage, and so he applied for a virginity test of her, which was permitted under the family procedure rules, and I think in fact still remains in place and still in force. And so he'd applied for this virginity test of her, and she was completely devastated by this. She herself, as I say, suffered, she says, tremendously at his hands. He denies those allegations. And she was saying that, well, the World Health Organization, the United Nations, they condemn the use of virginity tests. How on earth is it right that the family court is entertaining actually ordering this woman to undergo this test? And so he brought that case to the High Court, and I argued for a declaration of incompatibility, the current legislation, but he then provided her with a divorce once we got that far, and so that was the end of that case. So I've worked on quite a number of campaigns, and I'm working on other campaigns such as criminalising sexual harassment, which is a key component of the Istanbul Convention, to make period products freely available in England and Wales, because they are available now as of this year in Scotland, which is marvellous. And I know you're doing brilliant work on making sure they're available here as well at King's College. And the decriminalisation of abortion. So there's still, and you know, some of the things that I feel like I'm doing, I'm sometimes working in silo. You know, there are lots of campaigns, but it's about bringing them together and recognising that you might win one and you might have one success, but there are structural endemic issues as well, which can be very culturally rooted, such as the minimization of domestic abuse, or I think there's often a culture of disbelief as well when it comes to women alleging rape and domestic abuse and coercive control, which plays out tremendously in the family courts in a way that it doesn't necessarily, I think, perhaps within some sectors of society. So there's a mismatch perhaps between attitudes and beliefs generally in society and what's happening in the courts.
Definitely. And you mentioned your work there on decriminalizing abortion. I know particularly in the context of the recent decision in the US overturning Roe v. Wade, and even myself coming from a country that only legalized abortion 4 years ago, I'd love to know more about decriminalizing abortion in England and Wales, because I feel like that's not a topic that often comes up.
Yeah, I mean, I think most people believe that abortion is legal in this country or is decriminalized, and are surprised to learn that in fact it is a criminal offence, and there are exceptions which allow for women to have abortions in this country, but they are very strict in terms of the way in which the law has been drafted, perhaps intentionally so. So I'll just go back to the late 1800s, the Offences Against the Person Act, which criminalised women for effectively procuring their own abortion. So, for example, ordering abortion pills online or something of that nature, or taking a noxious substance to attempt to have an abortion at home. Now, that was criminalised during the Victorian era, when women didn't have the right to vote. They were not even allowed into the House of Commons. The light bulb hadn't even been invented. And if a woman is found guilty of this offence, she will be kept in servitude, is what the law says. So will potentially face life imprisonment. And there are other abortion-related offences that came subsequent to that. And you might think, well, surely this law isn't actually enforced. It might be on the statute books, but is it actually happening in practice? And it is, in fact. FOI requests that have been done by journalists have shown that the police have investigated women for attempting to procure their own abortion. And there are 2 women currently on trial for abortion-related offences. One in Oxford and one in Stoke-on-Trent, who potentially could face a very long time in prison. And there was a recent article about a woman who did spend 2 years in prison for an abortion-related offence. And the Times did a brilliant piece with her, and she spoke about the fact that she was in a coercive and controlling relationship, and so she'd been forced, as she said, by her ex-partner to take abortion pills when she was much further along than she thought she was. And then subsequent to that, the police arrived at the hospital, and then she was arrested, investigated, prosecuted, spent over 2 years in prison, and now has a criminal record. And then, of course, then we have the 1967 Abortion Act, which makes abortion available in certain circumstances. So 2 medical doctors have to sign off on an abortion, and it can only be provided for reasons such as a grave risk of harm to mental health or potentially physical health injury. So what is happening is that women have to pathologize themselves as having a mental health condition to justify having an abortion. They can't make a free, independent, autonomous decision exercising their agency as to what they want to do with their lives or their bodies. They're having to justify it on these very strict grounds, which in my view is wrong, and I think arguably contravenes Article 8 and potentially other rights. So I'm working with McAllister Olivieris and Anthony Metzer QC, or Casey now in fact, to challenge the Abortion Act 1967 in the way in which, of course, it's been drafted, and the fact that, as I say, it's resulting in women such as one client who went to an abortion clinic, wanted to access reproductive health care. Actually, they asked her why. She said, because I don't want to have children. And they said that was not a reason. That was not a good enough reason. It was not a lawful reason, in fact, to access reproductive health care. And she had to provide a mental health justification, which then she did. She said, well, it caused me such distress, I could have a mental health breakdown. And she went on, she was then able to access an abortion. Now that's on her medical records. So you can see that the problems and the obstacles that women experience in practice, and this isn't reflected in the law, quite to the contrary.
It's amazing to hear about all the different campaigns you're involved in and just to the extent of it. And I suppose you mentioned before about how these kind of all fit together. And I suppose, how do you see all of these issues fitting together? And I suppose in particular, what kind of structural issues and causes do you think are at play with all of these issues of gender justice across the entire legal system?
Well, I think it's the fact that obviously when, the law, as it was first enacted, going back centuries ago, women were not allowed to practice. I mean, it's wonderful that we're here celebrating 50 years of women at King's, but, it's only 50 years. My grandmother couldn't have studied here, for example, and, recently it was just 40 years at Queen's. So, we have still a long way to go because the laws which are in place historically and still enforced, for instance, thinking about the reasonable person test when it comes to rape or other forms of violations against bodily autonomy, it's often interpreted as a reasonable man, what a reasonable man might think. So within rape, as an example, is that, did he, subjective test, reasonably believe that she consented? Would a reasonable person, or reasonably, would you think that she had consented in that context? And often I think that the way in which that plays out is that, particularly in front of male judges, they may apply their own subjective view about whether they thought that a reasonable person would consent, whether they thought she had consented. And there are lots of biases and prejudices that play out, particularly with rape stereotypes and rape myths and rape tropes. So even though the law was updated in 2003, it's still, I think, lagging behind other legal systems, for example, in Sweden, where they have affirmative consent that's now in place. So that in some respects, the onus is then put on the defendant and having to show, well, what steps did you take to make sure that you believe that she consented and that she said that she wanted to have sex? There's almost a welcomeness or mutuality standard, as Catherine McKinnon, a legal scholar, might refer to it as. So I think we still have a really long way to go. And I think that some of these attitudes are very much ingrained, not just within the law, but how it's implemented, and also the way in which the legal system itself operates, including legal professionals, and the fact that our judiciary and lawyers don't reflect the diversity and inclusion of our society. Unfortunately, it still is very much skewed towards a particular demographic, often very male, privileged, white, cis, and that, of course, doesn't reflect those people that are often in court who may be destitute, impoverished, people of colour, experiencing a range of intersectional inequalities. And I think that, for many judges are perhaps not aware of what it really means to live a life like that, and me, myself, I come from a working class background. My accent has changed enormously over the years. I remember when I first started out, so I did my undergraduate at Keele University, so I could live at home and I could work. So I worked part-time in my local supermarket from when I was 16 to 21, so all the way from college through to university. And then I went to bar school. And for me, that was one of the biggest shocks that I've ever encountered, because, prior to even going to law school, I'd never met a barrister before I was at Keele. So that was one of my first experiences when I realized actually I could become a barrister. And this is, there are other people at the bar that look like me and maybe not sound quite like me at the time, but, I felt like it was suddenly attainable. So I changed my career path from becoming a solicitor to a barrister because of work experience I'd done. I'd happened to encounter a woman in Stoke-on-Trent Crown Court who really changed my view about the law and where I saw my future. And then I came to the bar, and as I say, it was quite a cultural class shock in particular. So every single time, or at least I felt like that, I went to an event at Lincoln's Inn. You have to dine, you have to do lots of dinners. And I was constantly asked about, my accent, where I'm from. I say book and cook and Luke, and you know, and when I said, oh, I'm from Leek in Staffordshire, and they'd say, oh, I've never heard of that. Where's that? And I'd say, oh, it's, you know, near Stoke-on-Trent or Manchester. Oh, anything past Watford Junction is the north. And so, you know, it's funny, but also it's kind of a reflection of the fact that I'm an outsider and I don't fit in. And then it'd be, you know, what school did you go to? Obviously, I went to a state comprehensive school from a single parent background. Who's your father? You know, so obviously I'm instantly feeling very much like an outsider. And I felt like that continued to play out at bar school. But because, you know, my mom had worked so hard for me to get to where I was, that I was absolutely damn sure I was going to get pupillage. And so I did everything you possibly could in that year to get pupillage. And then I did. I got pupillage at the end of bar school, which, you know, having gone to Keele was, I suppose, looking back, really a miracle in some ways. And then I did my master's at Cambridge and went on since then. But I did feel like the class played like a huge part in not really fitting in, and maybe seeing things from a different perspective to how my colleagues see the legal system and how my colleagues see the legal profession. And I think unless you're part of the establishment, looking in on it, you have a very different experience of often what's happening in court, especially when I speak to other counsel in a case. I'll say, I can't believe I've heard this said. And they look at me with surprise. And I think, but that was, you know, that I'll give you an example of a case where a mother had gone to court and she had said that she was a victim of rape and domestic abuse and control. And the judge said to her, a very senior judge, that if she carried on with her allegations, then he was going to make sure that her child was adopted or put into care. And this mother was crying. I mean, she was very distressed, and I heard the tape afterwards. And none of the barristers did anything about that, you know, and everyone said she couldn't appeal that, and, you know, what had happened, it's just one of those things, it's what happens in court. And then, you know, she came to me, and way out of time, about a year out of time, ended up appealing one of the decisions from that judge. But it showed to me really the difference in the way in which some barristers and solicitors and other legal professionals, they understand and interpret these decisions versus my experience, and some other women and marginalized people experience these decisions and the way in which they reflect on them. And I think because of that, we're able to push boundaries and progress within the legal system and challenge it.
I suppose thinking from that, and apologies if this is quite broad, but I suppose what kind of solutions do you think there are for these kind of issues in the legal system at the moment, particularly because these problems continue to persist, and probably will continue to persist until something's done about them? So what kind of solutions do you see working or think could possibly work?
Yeah, I think that, so one of the things I've been a really strong advocate for is gender quotas. And obviously I can see some of the difficulties with that, and that when I talk about gender quotas and saying that, you know, the judiciary, for example, 50% women, 50% men, I think is obviously the kind of system that should be in place. But of course, one of the difficulties with that is that you can often end up then with very privileged white women in those positions of power, rather than it being a reflection of society. But I think when you look at the Supreme Court, for instance, and you have 3 white men named David, who I'm sure are extremely good at the job that they do, but there are also equally many women and people of color that are also very good at the jobs that they do, and yet a distance, marginalized and invisible from the echelons of power. And, you know, if you look again at the Supreme Court, there's one woman at the moment sitting there, and there has never been a person of color ever to sit in the Supreme Court. Now, is that really a democratic system? You know, that is supposed to be, you know, a place that people put their trust in the justice system. And the justice system needs to, as I said before, needs to reflect the kind of world that we live in. So I think quotas would be one step forward, perhaps. And one of my, I suppose, greatest concerns is class being one of the real issues at the bar, because it's extremely expensive, as we know, to go to university, very expensive to go to bar school. The scholarships are brilliant within the Inns of Court, but, you know, they don't go nearly far enough in ensuring diversity. And I think that's a really significant obstacle that's often overlooked. So I think the legal profession, we need to work harder to have greater diversity. But in terms of the law itself, there are some brilliant organisations like the Good Law Project and Joan Moore and Casey there, who challenges the government and holds the government accountable and uses the law as part of that process. There's the Centre for Women's Justice, which does brilliant work within the criminal justice system in challenging the law and holding the CPS and the police to account. And I'm setting up my own organisation in partnership with the Good Law Project to do exactly that and to continue doing more of this work to change the law for women, which will be called Right to Equality. And we're going to be launching that next month. So I'm really looking forward to that. So hopefully more work within an organisational capacity with more people on board.
Brilliant. And I think from that, I'd love to open it up to the floor if anyone has any questions, or for those of you have any, if anyone does have any questions.
Yeah, absolutely. I guess, yeah.
Thank you so much. That was a fascinating talk. It was wonderful to hear about your career and work you're doing. Building on the question you were asked about how effectively the law protects women, I was wondering what your views were on how effectively the law protects trans women.
To be honest, I don't know nearly enough about that area of law. So I don't really feel that I'm able to properly comment on it and do that question the justice that it deserves. But I'm a big trans advocate and trans supporter. And from trans people that I have represented, not specifically though within trans aspects of the law, but generally within domestic abuse. I mean, they're one of the most marginalised groups in our society, and I suspect that the law isn't properly reflecting their experiences, and perhaps they're experiencing greater levels of injustice than other groups. And I know that's a very hot topic, so I'll leave it there because, as I say, it's outside of my area, but thank you.
Thank you so much. It's really interesting and inspiring listening to you. I just wanted to ask what you thought. I mean, I often think it's, it's ironic. We're very privileged sitting here at Cambridge, at King's, and obviously this is only open to a very, very small elite group. And how much you think that the bar and, getting to the stage that you've got to is still very much a closed society. I mean, it's still a very hard, to get into Cambridge, to get into the top, leagues and that sort of thing. Obviously, scholarships and that are limited. Obviously I'm not from England. So I can relate to people asking you about your accent and where you're from and not knowing where you're from and feeling that sort of, that sort of alienation and marginalization. So I'm just interested in your perspective of how much you think the legal system here has changed to open up to new, people coming from new environments. And thank you so much.
Thank you. I think we need to do a lot more to open up to new environments. And you're right, this is obviously a very privileged context that we find ourselves within, and we're very lucky to be here. But those people that are affected by the law are obviously distanced from being part of making the law in particular. So looking at the domestic abuse bill as one example, now the Act, they were represented largely by organisations, which was important, so their voices came through. But still, when the law is enacted, it's within Parliament, it's a very powerful institution. And that in itself isn't reflective as well of the diversity of our society. So it's another barrier. And, I think that the class issue is tremendous. I mean, when I look back at kind of my life to getting to here, I almost sort of think it is a miracle that I am here, to be honest. I worked so hard. I mean, harder than most people, working all the time as well as going to university. But it was just sheer commitment and dedication and an obsession with working, I suppose, and still never stopped working. But when I look, especially, I suppose one of the most frustrating things is no offense to the men here, but is how many mediocre men there are in very senior positions and how very few mediocre women there are in very senior positions, because we have to work so much harder to be recognized. And the fact that so many women are passed up for positions who are truly worthy of those positions for often very privileged people. And, you know, I don't believe we live in a meritocratic society. And I look at how hard I've worked compared to, say, how hard a friend of mine has worked, who came from a wealthy background, who went to private or public school, had immediate access to Oxbridge. You know, like, yeah, for some people that will create some resentment. I mean, I'm very lucky that I've done very well, but for others, they might not have achieved as much as I have. This idea of, well, if you work hard, you will get there, but not everybody can work this hard. And actually, it wasn't always that fun. It wasn't easy. I missed out on a hell of a lot to get here, made a lot more sacrifices. So yeah, I mean, when I think about, I went to one of the most deprived colleges in the UK, but I absolutely loved it. And it was actually probably one of my best experiences. I love being around the people. And I thought that the quality of teaching was phenomenal. We had very, very small classes. And I remember my sociology teacher, Mandy, who I absolutely love, and I credit with so much of what I've achieved thanks to her. And she looked like Pamela Anderson, but she was a proper Marxist. And she absolutely loved Karl Marx. And she could just cite him nonstop. And she was amazing, from a really working class background. And I remember saying to her, you know, should I apply to Oxford or Cambridge? And she said to me, oh, why would you want to go there? It's full of snobs. And so that was the end for me when she said that to me. And I'd ordered the prospectuses. I remember showing my mom them, and she's like, oh, you don't want to go there, you know, go to somewhere local. That's what everybody does sort of around here. And that's what I did. So it's, you know, it's a cultural attitude as well. It's, these places are not always accessible.
Thank you very much for everything that you have shared with us to date. I wondered if it's perhaps an area of law that you haven't dealt with as much, centered, given you're centered around family law cases, but would you think that mothers in particular in criminal trials involving sudden infant death syndrome or the sort of, unexplained deaths of young babies or children, is this an area of the law you know much about or are familiar with, or think could potentially be reformed so that women or mothers aren't often scapegoated for just unexplained deaths in their infants?
It's a great question, but I just feel it's outside of my expertise. I'm sorry, I just can't do that justice.
Hi, I wanted to kind of talk about the experience of legal training and the way that legal training itself is biased, because I'm taking a law course this year, even though I do social sciences, and my experience of the sort of the law degree here through doing that course is very much that it's about how to become a lawyer rather than any critical understanding of the justice system and its injustices and its unfairness. So the paper I do, which is based on discrimination and injustice within the legal system, I've seen a lot of lawyers kind of, you know, scoffing and turning up their nose at like having to be in that room and listen to stories of racial discrimination and things like that. So have you any experience within the training you've had, or your experience of people who've had sort of law degrees or training who clearly haven't had to deal with the injustice factors of the law and the way that their training has actively entrenched that rather than provide any means of change?
Yeah, that's such a good question. Thank you. I didn't receive any training thinking about the injustices of the law. I don't recall receiving any training of that nature when I was at bar school, certainly, which is really an important place, I think, to study that just before you go out and you're let loose on the public. But when I was doing my undergrad, I was able to take certain modules, papers as they're called, here. So I was able to focus on things that I was particularly interested in. So obviously I did do that as well. But I think it's an integral part, isn't it, of understanding the law. And I think one of the issues is, you can study the law as if you're looking at it through a microscope and looking, the black letter of the law and interpreting it in this way. Or you can look at the law as a social science, which is obviously what I've chosen to do. I did my PhD between the two departments of law and sociology, but predominantly in sociology, because I'm interested in critically analysing the law and examining it as a social institution. And I think that the law has to open itself up to these types of criticisms. And unfortunately, this notion of you need to protect the integrity of the law and you can't bring the profession into disrepute, unless we're able to criticize it and hold it to account and shed light on some of these injustices, we're not going to have the kind of progress that we need. So I think it's really important. I think we need to change the way in which we teach law. Some of my students that are doing dissertations on legal-based topics, the whole purpose of that dissertation is to critique the law and to look at other ways around. I mean, I love Catherine McKinnon. She's a mentor to me. For those who don't know her, she's a phenomenal legal scholar and has reshaped the law around sexual harassment, pornography, prostitution, rape, and so on. And, her entire thesis is basically the state is male, the law is male, and it centers a male point of view. And we need to recognize that and then break it down. But she says the law is such a powerful institution and vehicle for change. And, I agree with her, it is. And so, but to change it, you need to be able to analyze and critique it. And I think that those in the legal profession are very frightened of that, actually. And I think particularly legal Twitter really struggles with the idea that you can hold judges to account. Yes, there's the appeal process for that, but equally you should be allowed to critically analyze judgments and to shed light on failures where they've happened, as should the media as well. And, if we're in such a privileged position of barristers, then we should be able to use our expertise and our knowledge and experience to do that. Otherwise, we're just doing one part of the process.
Thank you. I wonder what, from your experience, would you say is the degree of interaction you as a barrister have with clients versus interactions that the solicitor that's also working with you on the case would have with the client? Where do you and the solicitor either overlap or diverge in terms of client experience?
Yeah, I think that there are two different ways of answering that. One is what is sort of a usual barrister interaction with the client and solicitor, and then what I have with solicitors and clients, because my practice has changed so much now and having sort of quite a niche area of practice. So previously, I would often only meet my clients when I was at court. So I wouldn't often have that interaction before. In most cases, of course, legal aid or pro bono. And so there's just not the funding to have those conferences with clients, so that creates a barrier. Solicitors therefore have the sort of the hands-on client care contact, and then you're given the case just before you do it, and then you go off to court, you've read everything you should have, and then you turn up at court and you meet your client often for the first time, and then you'll try and continue with that case. It might take a year, it might take 2 years to conclude. But there may be difficulties with your diary, and so you might struggle actually to have that counsel continuity. Now, my practice is such that often clients will contact me directly and will say, will you please represent me? This is what my case is about. And then I'll try and find them a solicitor. So obviously I have a group of solicitors that I tend to work very closely with that are also experts in this area of law that I trust enormously. And they will contact the solicitor, and then we'll have an ongoing relationship that continues throughout their case. So it's a lot more hands-on and a lot more personal, and I will meet the clients and I'll continue working with them, because most of them, they'll go to appeal. So I'm doing a case at the moment in the High Court, which I'm very much looking forward to. It's 2 appeals. I'm representing both of the appellant mothers, and I'm arguing that the fact that there is no definition for consent to sex and no definition of rape in the family courts is in breach of their Articles 6, 8 and 14 rights, and that there needs to be a consistent definition. And frankly, in 2022, it's astonishing that there isn't any definition. So each case implements a completely different approach to deciding if rape has happened or not. And they don't follow the criminal definition following re-R of the Court of Appeal, reaffirmed by H&N. So I'm challenging that. And also the fact that there is no direction that judges have to give themselves or guidance on rape myths and rape stereotypes. And there is no law or guidance dealing with sexual history and how judges address that issue when raised by the accused. So that's due to be heard next month as well. So I asked for the two cases to be joined together. So for example, looking at that one, so I'll work very closely with my clients, and I represented them, one of them at the trial for almost a week. And so we'll continue. But I think just to add to that point, one of the really big issues that's facing the bar, and I know there's a lot of media attention, rightly so, on the criminal bar and the fact that it's underfunded, and that as a result, there are all sorts of issues with it and clearly a broken criminal justice system. But from the family bar's perspective, it's really not much better. You know, I'm being paid less now, obviously with inflation as well, but the fees have been cut since I first started out in 2011. So, you know, to do an appeal of a rape case I've never done before, such as the one, as I mentioned, I'm doing next month, one of them I haven't done before. And then you get a bundle of papers for that trial, which, you know, can be anywhere between 300 pages or 2,000 pages. And you have to meet with the client often, and then you have to read everything, of course, and do your skeleton argument, your grounds for appeal. That will take probably about 3 days to do it properly, to really craft what it is that you want to say. It's quite hard to get permission to appeal. And for that, I'll get paid £94, which is a fixed fee. And so it's an incentive not to appeal, not to hold judges to account when they've erred in law. And that's a fundamental problem, right? Because that means that the justice system has to be almost affordable. If you can't afford it. And you know, one of the issues is a woman was writing on Twitter that she couldn't find anyone to take her appeal. And she asked me, even if I would take her appeal, I just didn't have the time or the resources to spend what would have probably been about 4 days on that case for £94. I mean, even if she privately paid, I wouldn't have had the time to be able to do it. But it's impossible. You're being paid around £3 an hour for that. So it's a really big issue. And I know the Bar Council are looking at this, thank goodness.
Thanks a lot. So following on from the earlier question on legal education, now the faculty have looked a little bit into the broader aspect of diversifying the curriculum. And I just wondered from you, and also maybe from your students, Beth and Rose, one of the key issues which we get when we try to sort of broaden and take into account more sort of on the ground aspects of how the law applies is, oh, it's so difficult to fit that into the already very tight curriculum. We have to in tort cover this and this and this. We have to in contract cover this and this and this. So I wonder where an appropriate balance lies in your views. And is it that in particular papers, in your view, there's a particular need to do this? I don't know, in criminal law, perhaps, CSPS, maybe other papers. And just as a broader factor of context, so in Germany, where I did my legal education, we're not tied to 3 years. We actually have most people doing perhaps 4 years of legal education before they, and it's not necessarily fixed for a particular number of years, which of course is tied into the broader context that we don't pay as students for our legal, for any university education. So I guess we can't really tweak all these parameters, but within the 3 years, I suppose we have, where would you say is the best balance between, well, you know, educating people as to the doctrinal bits, which you need to have to be a good lawyer to win cases, but also having a proper understanding about the application of the law in practice. Thank you.
Do you want to go for it, Beth?
I'm quite happy to answer that if that's all right. So I think there's a degree to which we look like, at least with law in Cambridge, there is at least one compulsory module that you have to take in first year, which does not form part of your qualifying law degree. I think it's very possible that that could be replaced with a kind of law in practice. I think I'd also gently dispute the point made earlier that the degree itself teaches you how to be a lawyer. I think there's legal training post-degree for a reason. So I think you learn a lot about the substance of the law within your degree, but the practice of the law is a different thing. I think it's also worth mentioning that I genuinely very much would support implementing looking more widely at the law and its policy complications and how it can affect people I guess in the real world and the disadvantages they face. I think it's a wider question than just law though. So for example, as I understand it, in natural sciences, they learn how to use AI quite early on in their courses. And at no point is there any diversity training in the use of AI. Obviously, they're completely different things, but both of them have a major influence on how the wider world actually functions. So I think it's about looking not just at law, but also about the way that we as a university take our disciplines on a diversity basis. I guess the other thing to look at is whether there's a meaningful commitment to particularly decolonization, because often courses that are offered in the law faculty are advertised as decolonized, and then they do not meet the expectation that's instilled in that advertisement. And I can certainly attest to that, having dropped one subject because it didn't meet that expectation. I do also understand Henning's point though, which is that as the syllabus goes, it is packed. That is not an excuse at all for the absence of diversity training and looking at how the law functions in practice. But you would be very hard pressed to find a point in the current modules that we take that are obligatory to fit an extra bit in, which is why I think it's maybe important, well, obviously important in first year to look at changing that compulsory module that is not part of the qualifying law degree, of which I will not mention the name, to perhaps look at diversity in practice and the discriminations that in real life the legal system might enable. Beth, I don't know how you feel about that.
I think I would agree about the unnamed optional paper. And I think even things I suppose even paper 14 and looking at legal skills and methodology is a really crucial paper, but we don't, this might be quite law specific, but we don't get a chance to really look at the practical implementations of how to also examine the law through a sociological lens or how to examine it through an intersectional lens. And I think expanding that practical training and having it across the 3 years, and even if it isn't adding an extra topic, but whenever we do a topic in criminal or in contract or in land or in anything like that, adding in that interpretation, that analysis that goes beyond just kind of what the law is and more looking at its implications and also how the creation of that law might have been informed by prejudices and biases in society as well.
Yeah, I think your course conveners play an enormous part as well. I'm just making sure I'm not talking too much because of the time. We've got 5 minutes left, by the way, guys. We do have an enormous amount of discretion in course conveners and what they recommend. Your supervisors tend to be very happy to point you towards diversifying your syllabus and the criticisms that you're taking of the law. But I would say that it comes on a very self-generated purpose, basis even. So yeah, sorry, I realize I talked a lot, but that's another question.
Do you think that the adversarial system is one which tends to foster discrimination as opposed to the continental system of dealing with matrimonial law in particular.
I mean, like inquisitorial
Yes.
system instead. Yeah, I think that's probably right. The Ministry of Justice did a report called the Harm Report, which was published in June 2021. And one of the issues that they identified was the adversarial system, and how it does, I suppose, foster quite a lot of hostile feeling within the courtroom, how this notion of truth has to out, but by one attacking the other. And then, of course, as a result of that, you see there's kind of a very binary approach that's often taken. And then you see issues like tropes and stereotypes and sexual history and things play out within that adversarial system. Yeah, I mean, I do think that is one of a very significant disadvantage. How it might look in terms of another system, though, that's something that I don't necessarily have experience of, and I'd be really interested to look at perhaps how it might work as opposed to the adversarial approach. Just thinking about some examples of some of the adversarial, some of the ways in which things I think have perhaps gotten really out of hand in court, where you need to have sort of like a judge that's going to robustly case manage the case. Otherwise, I think it can descend into real chaos of mudslinging at each other, and then the system can become a place for further re-victimization and re-traumatization rather than the truth outing and protections being put in place where they're required. So yes, I think that is a big issue.
I very much would like to echo your comments on progressing through legal education. It very much seems unchanged from when I went through it. However, I would say that the Oxbridge colleges, the Inns, the Judicial Appointments Committee, all very focused on increasing diversity, but seem to come up against many obstacles in actually attracting the right candidates. And to the extent that the bar is not particularly well funded, as you very well illustrated, it's going to be difficult for people to progress through the profession without independent wealth. And the balance between the increased focus in increasing diversity versus the harder situation on costs of actually affording a legal education. I wonder what your view is as to whether it's easier now or harder now than when you went through that process.
Yeah, I think it's a good question. It's a really difficult one. I suppose it'd probably be better to ask someone who's currently going through it, but for mentoring those that are going through it, that have come from lower class backgrounds and more marginalized, they've only been able to get there because of scholarships that have been provided through the Inn. Otherwise, they wouldn't have been able to have gone to bar school. It just wouldn't have been accessible for them. And then in another case, she was able to get to the bar, but she didn't get the full scholarship, which meant that she dropped out after a year of doing it part-time, couldn't afford really to go back and continue with it. So I think that, has it become, I don't think it's got any better, but I'm not necessarily saying it's got a lot worse when I was there 10 years ago.
I mean, people should be careful what they wish for. I wonder if you have any advice you would give to, say, a sixth former, someone choosing their university career, choosing the university subject and thinking about their career, if they wanted to pursue a legal career, and as to the relative advantages of the bar versus the solicitor's route. Yeah,
I think a lot of it comes down to personality and what you want out of it. As I say, I was always thinking I'll become a solicitor, had never even contemplated the barrister route. And I think a lot of sixth formers are perhaps not even aware of the differences within the legal profession between barristers and solicitor route, particularly at more comprehensive schools, perhaps. So I think informing them of that and having the opportunity to do work experience in those areas is important. Obviously, with solicitors, you have the advantage of having a salary, sick pay, maternity, paternity pay, pension, and so forth. Whereas, of course, as a barrister, as a self-employed sole trader, you don't have any of those advantages at all. And so, particularly you see a really high attrition rate as well for women at the bar, understandably, because if they go on to have children, and some make sacrifices in not having a family because it's not affordable and they're the breadwinner, then there is no maternity pay available. And criminal courts are now opening on weekends. There's to push for that in the family courts as well. The immigration courts, I still practice very part-time, and the immigration courts are complete and utter chaos. And so, you know, if you're having to prep the night before and you have 3 hours of prep to do, and you're having to do it before you go to bed, you know, you're not going to bed till 1, 2 a.m. You've got to get up early, you've got to get your kids to school and so forth. It's just not practical. Yeah, the reality of life. And if you're being, you know, if you're doing legal aid work predominantly, it's just not affordable. A very close friend of mine left the criminal bar. I was very sad about that. A junior barrister, extremely competent, very good at what she does, very passionate as well. But she, you know, had a second child, and all of the money that she was making at the bar was just going to childcare. So it just wasn't affordable. You know, she literally wasn't making any money after she paid a tax, clerk's fees, etc. And so she left and is now still a barrister, but she's an employed barrister rather than self-employed. So, you know, there are other ways around it. You know, there's the employed bar and so forth, but it's not going to increase diversity. And I think what's interesting is if you look at sort of the lower paid areas as well, so immigration, for instance, being one of them, is extremely poorly paid. And you'll actually find practitioners tend to be more diverse. And I think that's because there's an expectation that they will take the work. And, you know, you see this as well within the clerks' rooms, not so speaking about my own chambers, but broader afield. You know, they'll put that work on to certain members of chambers because they'll think they will do that for, you know, 100 quid or 50 quid or whatever it is. You know, and I've come across, you know, a very junior member of the bar, still a pupil who experienced racism within a particular area of the country when she was sent out there to do criminal work. And as a result said, you know, I don't want to go there because they keep thinking I'm the defendant and I'm not. And she felt very uncomfortable in that space, but was still expected to go nevertheless because someone has to do that work. So you get the Crown Court trials as explained how that happens to me. So, you know, I see that's a real issue. But then what's interesting, I suppose, is if you look at the criminal bar, when you look at those that are progressing, and the same at the family bar with legal aid, those that are very senior are often still very privileged in terms of it predominantly being white, privileged women or men, and yet the lower end, you see more diversity when it's lower paid work. So
one final point on access.
Yeah.
There was an academic from Southampton, retired now, Professor Brian Waite, who proposed earlier this year setting up a scholarship for white working class people to progress to Oxford and Cambridge into the professions. And he came in for a lot of criticism for the restrictions he wanted to place around access to his scholarship.
Yeah.
Would you be in favour of scholarships restricted to the white working class?
I would be in favour of a scholarship restricted to working class people, but not white, because, you know, I don't think that white people as a group on the basis of their of being Caucasian means that they're discriminated against wholly. But of course, being working class is an intersectional inequality that many people experience. So I think that the working class element appears to be right on there. Yeah.
Okay, I think just in the nature of time, we may need to wrap up there, but obviously, as per, we'll all be around for questions after. And thank you very much, guys. We really appreciate you coming.